Yeah, hi. Good morning, everyone. So I just realized today morning wasn't a great idea scheduling a class on Sunday morning. So all I'll say is that I feel the pain as well. Should have thought about this in more detail. Anyway, yeah. So in terms of what we plan to discuss today, it is, I think, a good culmination of a lot of the points which we spoke about in the last class, which was essentially to try and ascertain the certain fundamental prerequisites which any case which essentially seeks to go to trial or to a full-fledged adjudication has to meet, in the sense of jurisdictional maintainability, limitation, etc., etc. So now you've seen that there is essentially a collation of two processes here. You've had the client come to you, you've had the client describe to you in detail what his or her case is from their perspective. Subsequently, you have independently applied your mind not just to the facts, but also to the underlying legal principles which you will have to contend with going forward. So, therefore, we are now at a stage where both of these processes have been completed, or in an ideal situation, would have been completed. And now, therefore, we are at the stage when we can really enter into the first, if I may call it, hardcore process, which essentially is crucial to the entirety of the trial going forward. Now, what we are talking about today is drafting. Now, primarily, I will be focusing on drafting of pleadings, because essentially this is a course focused on the litigation process or the arbitration process. But initially, we will go through certain fundamental prerequisites or best practices, if you would call it that, which would apply to all forms of pleadings. I'm sorry, which would apply to all forms of drafting, including elements which don't necessarily have to be linked to a particular litigation. For instance, legal notices, drafting contracts, agreements, etc. So, at the outset, why is drafting so important? See, ultimately, as I mentioned, it is wrong to fetishize any particular element of the litigation process or the stage of a trial in preference to another, because all of these aspects, as I mentioned in the very first class, all of them are equally important, and only once there is this perfect symbiosis between them can you actually expect to have a positive result or a successful prosecution or a defense of the case, as the situation may be. Now, having kept that in mind, it is impossible to not stress upon the importance of drafting, for the simple reason that, unlike in the case of, say, an oral argument where you will have sufficient leeway in terms of modulating your arguments, possibly making strategic withdrawals, etc., depending on the response from the judge concerned who is listening to your case. In the case of a written pleading, once you put a particular averment or a factual position in writing, it is almost impossible to be able to resile therefrom in the future. This is in the context of pleadings. In the context of documents which originate transactions, for instance, contracts or agreements, there is an entirely different set of consequences, equally problematic, in as much as the kind of clause which you put into the agreement might determine the rights and liabilities of your client going forward, and the smallest of vagueness or the smallest amount of carelessness in a one specific clause can have devastating results. Now, one good example of this is the recent litigation which you must all have heard of. This is in relation to the controversy between Ranbaxy and the Singh brothers. So, I'm sorry, Ranbaxy, which was owned by the Singh brothers, and then, of course, it was sold to a foreign investor who then subsequently discovered that there was some, let's say, hanky panky in the transaction, and then sued successfully for a gigantic amount. And now, ultimately, the Singh brothers, have been reduced to penury because of this particular litigation. So that is a very good case study, because if you in fact notice, almost the entirety of the award turned on the wording of the indemnity clause in the agreement. And if there was a tweaking at that stage by the Singh brothers in terms of ensuring that that clause was indeed not so widely worded, possibly the result might have been completely different. So that is one obviously recent example of how the let's say a wording of a clause which does not adequately take into interest the what the client really requires might lead to devastating results in the future. Now, this may have occurred for any reason. The client may not have disclosed what was essentially underlying what was the underlying problem to the lawyer. So therefore, there was absolutely no red flag for the lawyer to try and tweak a clause which is otherwise standard in nature. So, therefore, it is important to understand that even the smallest mistake in a draft, in a written draft, can lead to devastating results. Now, with this background in mind, one must also look at the aspect of pleadings, not just in terms of avoiding roadblocks or pitfalls, but also from the perspective that it is the first enunciation of your story. Now, see, ultimately, the entire process of trial, drafting, oral evidence, cross examination, oral submissions, all of these ultimately are in aid of telling a story. And the very first manifestation of the story on behalf of your client is the written draft or the pleading. Now, therefore, it is very, very important that the pleading is a fine representation of what your case is and also has the persuasive value to be able to sway any person who reads that particular draft. And when I say any person here, please bear in mind, we are not talking about lay persons. We are talking about a judge, an individual who is specialized in that particular area, who has vast experience in terms of how these litigations are fought. And therefore, the benchmark which we are seeking to achieve is obviously much higher than a normal storyteller, though the fundamental aspects of it remain the same. Now, with this background in mind, I will first try and talk to you about what are the essential prerequisites of drafting. Now, please bear in mind there is obviously a reasonable amount of subjectivity in terms of certain issues around drafting. You will find people who are completely averse to the use of complex terminology or complicated terminology when drafting a pleading. I do not agree with this absolute prohibition because, in my view, sometimes the use of complex terminology, provided the setting and the context of that word is proper and does not create any confusion, can be a fine tool for you as a lawyer to be able to get across your point more effectively to the judge. And naturally, the quality of the draft also in terms of its engagement with legal issues or let's say complex legal phrases definitely would be elevated if you use it properly. The problem is, people nowadays essentially just try to pepper drafts or any form of writing with complex words, and they don't really care about how it affects the overall let's say outlook of the piece in terms of the reader's perspective. So again, a caveat in the beginning, this essentials of drafting do vary from situation to situation, and there is no such absolute rule which one can propound for the same. Now, having kept that in mind, I want to first begin with fundamentals of drafting per se, not relegated simply to a pleading or any particular draft. Now, at the outset, let me take you through this reading material which I had shared. I had shared two of them. One, of course, is the one which talks about legal drafting in general. Now, this is an interesting piece, also has a small hypothetical example which it then tries to flesh out in terms of examples on how to draft. Uh, at the outset, as this piece tells you, the most important part of drafting can be summarized into three or four essential elements. Now, we will come to these elements one by one, but please understand that a draft, as we already mentioned in the previous sessions, can only be begun once there is mastery of the facts. So, when you talk about mastery of the facts, you are not just talking about having the ability to pour hundreds of pages or hundreds of paragraphs worth of facts into a document. When we come to pleadings, I will explain why it is very, very important for you to be able to discern what is to be pleaded and what is not to be pleaded. But at the outset, as a completely simplistic sort of benchmark, please bear in mind that the identification of the facts is not just in terms of the volume or the quantity, but the identification of the facts is in terms of what is relevant to be pleaded. Because pleading irrelevant things, generally people have an impression that even if you are garrulous in your pleading, even if you put in a lot of extra material, ultimately there's no harm done. That is incorrect. Harm can occur in two ways. One, your focus is completely lost. The person reading the draft essentially is not able to pinpoint your ultimate point, and that can lead to serious problems in terms of their assimilation of your case. Number two, pleading unnecessary detail sometimes gives the other side an eye opener in terms of what could be a possible defense to what you are trying to state. And therefore, you are the last person as a lawyer representing your client. The last thing you should be doing is telling the other side what are the possible ways in which he or she may be able to block your case going forward. So identifying the facts, very, very crucial. Once you've identified the facts, you need to research the substantive law. So a client comes and tells you, sir, I am a director, and this is what has happened to me. My name has been struck off the rolls because I have been inactive, say, for the last 4 or 5 years. That's something which has happened recently, a lot of controversy on the corporate law side. Now, obviously, you need to research the law. You need to find out what are the latest regulations. You need to find out how those regulations have been interpreted by the courts. And ultimately, you need to then apply those facts to that subject matter. Now, this is important because it seems very fundamental, but a lot of times you will see lawyers, especially in the case of legal notices, simply parroting what their clients tell them without any, let's say, engagement with the substantive law. Now, sometimes this is not problematic because, for instance, somebody wants to recover money in a plain sale purchase agreement. This may not be so problematic because ultimately the law is well settled and it's not something which sees a massive shift. But particularly when it comes to more contemporary areas of law or contemporary areas of dispute resolution, it is very, very important to ensure that whatever is being stated in terms of the facts is something which ultimately gels with the applicable law. Now, in terms of the drafting process or the skill, if one might call it, as we already mentioned, you obviously need to be very, very particular in terms of the kind of information which you are getting out of the client. As I said, clients will have a tendency to tell you only what they believe is relevant, which can be disastrous because, as I mentioned, their context only emanates from trying to secure a win ultimately, without really caring about engaging with the case of the other side or with the process which the court will undertake as a whole. Therefore, very, very important, again, I reiterate, before a draft, to ensure that you have the complete picture. Now, a client may hide something from you, answer wrongly. That's something you really can't help. But ultimately, it should not be a case where you think 5 years down the line, oh God, I didn't ask my client about this. And now look, this is completely it's created a complete mess for us. Very, very important thing. This is obviously something all of you who've done internships would have seen. It is important to prepare a rough draft expressing the fundamental points to the client at the very outset, because many a times what happens is that you will see lawyers draft extremely lengthy, complex, and well drafted pleadings only for it to be sent to the client and the client to say, oh, I never meant to tell you this, I meant something else. And that might be something extremely fundamental which completely obliterates the basis of that draft as a whole. So unless you are categorical, you are 100% sure in the conference which you have with the client that this is exactly what he or she intends to indicate, it is always a good idea to send across a brief draft at the very outset so as to ensure that you are on the correct path and that your hard work subsequently is not going to waste later. Now, obviously, this rough draft is also something which needs to be analyzed threadbare. It's not like the rough draft projects which you will submit, or at least which we used to submit. These are rough drafts which require, good analysis, and these are something which ideally should not be postponed to the final draft. Now, as I already mentioned in the beginning, you need to then research all legal issues, all applicable substantive law points. You need to analyze the draft from this perspective. And most importantly, as I mentioned, once you think that any part of your factual narration is something which might contradict your entitlement under the substantive law or otherwise create a problem in terms of an admission which the counterparty may use in the future, you need to be very careful and ensure that this is something which is then immediately struck off. For instance, to give you maybe let's say a very imprecise example, you have a particular dispute going on between your client and say a service center for the servicing of a car. Now, your client comes and tells you that, sir, I get my car serviced every single day at this particular workshop, and I've gotten myself a warranty from the company. And now, look, this is the service they did on the last occasion, and my car doesn't start at all. Right? The engine is sputtering; it's a complete wreck. Now he tells you everything, and he says, "Oh, by the way, just 2 months prior, I wanted to upgrade my music system, or I wanted to put fancy LED lights on my car. So I went to my, a friend who essentially does all this tweaking over the weekend, and he just put like this really fancy LED light for me." Now, frankly speaking, in a strict interpretation of possibly a warranty disclosure clause, you might have a problem if you used an unauthorized workshop or an unauthorized person to do any sort of modification to your car. Now, legitimately speaking, a modification, say to LED lights at the back of a car, would not have any correlation to why an engine is completely stuttering. But if you write this in your document, if you write this in your legal notice saying, "Oh, by the way, my client also walked into his friend's place and he had these two lights replaced, and then also the car was having absolutely no problems, it is only after servicing that it created a problem." So you may legitimately want to write that, but it will create a problem because you are now intimating the other side of an excellent point to at least try and confuse the issue or try and put you on the back foot. So very, very important for you to ensure that the initial draft is then pruned, or even the initial draft takes into consideration the fact that there should be no averment which will lead to a problem in the future. Now, naturally, you also have to then ultimately undertake a process more in terms of the language. You need to ensure that the draft which you are propounding is simple, it is accessible, and it is something which gets your point across. Now, this seems relatively straightforward when we talk about, say, slightly more simpler disputes. But when you talk about complex disputes involving multiple agreements, involving multiple parties, and a large time frame, imagine a construction contract which goes on for 7 or 8 years, multiple subcontractors, gigantic investments. So, trying to capture the complexity of these innumerable transactions into a draft is no laughing matter. So therefore, it is in that context that this becomes very, very important, that despite the complexity of the facts, despite the voluminous of the facts, your draft should be able to articulate a simple proposition going forward. Now, see, whatever we have discussed so far is something which essentially relates to the realm of common sense. And that is essentially not something which is very, let's say, strange, because as I mentioned, the fundamental aspect of a pleading ultimately is that it conveys a particular story or it conveys an arrangement if you are talking about transactional documents such as agreements, contracts, etc. Now, the only thing to be borne in mind is that the difference between these two, between pleadings and transactional documents, if I may call them that, is one, that in a transactional document, you can try and make that document as one sided as possible. Because ultimately, in a transactional document, always remember it is the agreement of the parties that decides the ultimate document. So, as a party, you have complete right to insist on any clause possible, subject only to the caveat that the clause shouldn't be illegal. So, if you have a contract with somebody, obviously you can't put in a term saying if you don't pay me back, you will be bonded labor for 10 years. You can't do that. But if you have a contract with somebody, you can insist on extremely onerous terms to be put in that draft to protect the interest of your client. And ultimately, it is a matter of agreement whether the other side agrees to it or not. So always remember, in a transactional document, you have far more leeway in terms of trying to make that document one-sided. if you may use the common phraseology. And that is something which is ultimately what you are expected to do as the representative of a client. Now, what I intend to say here is not that every contract you make should be manifestly unfair to the other side, but as far as protecting your legal interests is concerned, this is a stage where you have complete leeway. Things are a little different when it comes to pleadings, and which is why they are a little bit more complex, in the sense that when you are making your pleadings, ultimately you are now no longer at a stage where there is going to be an agreement between the parties. You are definitely in contestation at that stage. So at that stage, whatever draft you make must ensure that it is something which is practical in the sense of your ability to be able to establish what you are saying. Therefore, you will find multiple pleadings, multiple drafts, where the story which is sought to be made out puts such a massive onus on the person who is actually attesting to it that it becomes literally impossible at a later stage to be able to prove what you are saying. Or it comes to the stage where your case is built on having to establish each and every element of what you are pleading, and the other side manages to knock off one or two aspects of what you said, and that helps in creating prejudice in the mind of the judge who is hearing the case as to the truthfulness of what you are trying to say. So please bear in mind this fundamental difference, that in terms of the draft in a transactional document, you are looking towards the future, a hopeful future, in the sense that ideally you would not want disputes to arise, but you are just trying to ensure that if they do arise, the interests of your client are protected. So therefore, ultimately in a transactional document, the most important aspect is that you must be firm and precise and unequivocal in relation to what your client wants. Avoid any vagueness whatsoever. Be very specific of the kind of rights which you want to take on and the kind of obligations which you want to be held accountable for. These are parameters which are distinct and separate from when you want to draft pleadings later. Now, in terms of the specificity of the agreement, naturally the context will vary. In a commercial contract, you will have a different set of parameters. In a family settlement, you will have a different set of parameters. So ultimately, for each of these individual elements, you will find a wealth of knowledge online in terms of how to draft specific contracts. In fact, drafting of commercial contracts is a course in itself in terms of the elements which you need to take a look at, in terms of the consideration, in terms of the obligations, in terms of timelines, etc. So please bear in mind this fundamental difference, if I may call it that, in terms of drafting of pleadings as opposed to drafting of documents or transactional documents, such as agreements, timesheets, etc. Now, what is important to understand is that despite these differences, as I mentioned to you earlier, the fundamental aspects remain very much the same in terms of conciseness, in terms of clarity, in terms of the terminology used, the knowledge of the facts, the comprehensiveness, etc., etc. So, therefore, please bear this in mind when you talk about the drafting generally. Now, this is obviously a small summary of what we've just discussed, and this is essentially an articulation of the same step, the same process in more specific terms. So you can go through this. Now, before I go to the next document, which is more critical in terms of pleadings as a whole, this I thought was a good summary once again in terms of what exactly you are required to do when you are drafting a contract. So whatever I've just spoken about to you in detail, a very, very concise summary in terms of what the drafting basics essentially are, is this particular slide: understanding the client's goals, identifying issues, researching the law, applying the research, and effectively communicating the terms to your audience. So this is a very, very good checklist or a benchmark, or some sort of a good practice manual which you can follow in terms of what is required to be done when you are drafting a contract. So this is as far as the basics or the fundamentals of drafting are concerned. Now coming to the real core issue which I wanted to speak to you about today: pleadings in courts. Now, when you talk about pleadings in courts, as I already mentioned to you, These are somewhat different from the pleadings or the documents which don't pertain to a trial per se, because this is a case where things have moved on to a dispute resolution phase. You are in contestation. You have to be very, very careful of the kind of stuff that you say or you plead. And you also have to ensure that despite that balancing act in terms of what you are required to prove, what you are not required to prove, ultimately there is a third entity, a judge or any quasi judicial forum, which is now going to take a look at what you've drafted and determine your entitlement accordingly. Subject, of course, to the other stages like oral evidence, submissions, etc. Now, when you talk about pleadings, this is a very, very good primer. This is, in fact, a webinar which Justice Nandrajog did during the lockdown. And it's a good primer in terms of what effectively is expected from counsels in terms of court pleadings. Now, as a very good summary in the right at the outset, in terms of what am I saying, why am I saying it, what am I required to say? Now, see, ultimately, always understand. Now, this is something we need to spend time on. Always understand that there is this concept of onus or onus of proof upon parties in an adversarial litigation setting. So, whatever the claimant pleads to establish his or her case, the onus shifts to the plaintiff. Whatever the defendant needs to plead to prove his or her case, the onus shifts to the defendant. So it is not just a question of saying everything possible to try and establish your case, but it is also a question of strategizing to see what are the things which you can get away with without pleading, and consequently taking the obligation to have to prove in the trial. Now, for instance, to give you a practical example, A and B enter into a contract. Later, there is a dispute. B says this contract was never signed. It's a fabricated document. It's a forged document. I don't know who signed this. I never signed it. Now, if as A, you are drafting a suit or you're going to a lawyer to get a suit drafted, there are, let's take two instances. To prove one piece of the puzzle, that B was in fact present at a particular physical location at a particular time, you need to prove the fact that he was indeed present and that you are able to attest to that presence. So the simplest way of doing this will be, I met, as A, you will plead, I met B at Cafe Coffee Day in Khan Market. I don't even know if there's a Cafe Coffee Day in Khan Market, but yeah, let's presume there is. In Khan Market on 21st of January 2020 at 5 p.m. B signed this document in my presence and I countersigned the same. So therefore, now you are required to establish that B came on that day, B sat in front of you, B countersigned. Now, if you want, now let's imagine a slightly more garrulous pleading. The pleading will say, I left from my house at so and so in the morning. I reached this Cafe Coffee Day at that time. Then I sat down, I ordered something. B came in after some time. He was wearing this color dress. We spoke for 1 hour about the business, about what is to be done, etc., etc. Ultimately, I told B we have to sign an agreement. Then B said, yes, I will sign this agreement for you. Then B put his signature on the agreement. B spoke again for 1 hour or 2 hours. Then finally B said, all right, I am leaving now. I will see you later. Now, you might believe, what is the big deal in terms of, evering all this? It doesn't really create any harm. Now, please take the 2 points which I mentioned in the beginning. One, it again leads to a loss of focus. Why is anyone concerned about what time you left? At least from your perspective, from the plaintiff's perspective, it doesn't matter what time you left your house in the morning. It doesn't matter what you spoke about before the transaction or after the transaction, because ultimately you are saying everything you spoke about is reflected in the document that you signed. Now, why does this create a problem? Because ultimately, what time you left from home, these are the sort of questions which the other side's lawyer is supposed to ask you, if at all, in a cross examination, to try and break your case. To ask you, what time did you leave home in the morning? How did you reach the place? What form of transport did you take? What were you wearing, etc., etc. So these are things essentially which the other side will try and ask you, if at all, at the oral evidence stage, to try and break down your story. So even though the client or the party is required to be conscious of obviously the background or the facts, you don't plead things in your pleadings which are unnecessary and give a handle to the other side to be able to postulate a strategy in terms of how to overcome it. Second problem, from a more substantive point of view, you just averred that you sat there for 2 or 3 hours, you spoke earlier, you spoke later, possibly as a defense lawyer. An argument could be made that they spoke for so long, evidently that would evidence some form of a disagreement in terms of what the terms had to say. So, as a defense lawyer, I can play on this and say that if it was simply a case of signing the contract, why would my client then come and sit with you for 3 or 3.5 hours? And you specifically say he speaks to you 1 hour before signing, then he speaks to you 1 hour after signing. Therefore, I put it to you that my client never really signed the agreement because there were disagreements. He wanted to have a second look, and therefore he went back home. You are frustrated at this refusal to sign, and therefore you signed the document on your own. So ultimately, see, in both these narrations, frankly speaking, there doesn't seem to be anything dangerous in terms of what you are saying. But unfortunately, as I mentioned, in the very nature of the adversary litigation process, it is incumbent upon you not to take on an onus beyond what you are actually required to prove, to plead, to actually prove your case. Which is why it's important to understand, what am I saying? So I am saying something to prove execution of a document. Why am I saying it? Because I must prove execution. Most important now, what am I required to say? So, to prove execution, you are not required to say when you left from home. You are not required to say that you had discussions 1 hour prior and one after later. You are not required to say what kind of color t shirt you were wearing. Nothing of this sort. So these are ultimately ancillary elements which a lawyer might try to rake up in a trial, again, as I said, naturally to try and obfuscate the issue. But as a party, you are not supposed to do this at all, because you are not the person from whom the other side is supposed to get inspiration in terms of how to confuse the matter. So this is very, very important, and it is actually something which you will probably agonize over for years to come, because there is always that slight insecurity which one feels when one thinks, oh god, if I leave this out, will it create a problem tomorrow? Will somebody say you didn't plead this? So therefore, it's a fine line, it's a fine balance, but it is something which is very, very important to maintain and keep, to ensure that you don't end up in trouble later on during the proceedings. Now, this is essentially one example of why we need to be very concise and precise in terms of what we are trying to tell the other side or tell the court in the written pleadings. Now, obviously, this is an interesting discussion on the evolution of pleadings. I'm skipping that because of a paucity of time, but this is something which you can go into at your leisure. Now, essentially, why are pleadings important? See, when we need to understand what we need to plead or how we need to draft, it is important to understand why exactly pleadings are there in the first place. So, as is mentioned in this particular note, pleadings are required to define the dispute, to understand or to enable parties to understand what are the facts which are sought to be established or brought into play, and accordingly prepare the counterparty in terms of what it is required to establish to counter the same. Most importantly, also to enable the person who is actually adjudicating to understand and ascertain the subject matter of controversy, which is essentially being tried before him or her. Now, therefore, the object or purpose of a pleading, which again ties into what are the essential prerequisites of a good draft or a good pleading, is that they must show very concisely and at a very quick glance the vital elements, vital facts. So we had an agreement, A and B. We have an agreement between us, dated 21st of January 2020. Vital element. Also, the pleadings must show what are the vital elements that are disputed. So, therefore, the defendant is going to say, "Oh, I completely deny this. There is no agreement dated 21st of January 2020." Now, even from the plaintiff's perspective, let's say you've written a legal notice to the defendant before you file the suit. And if his response is, "I deny," then in the plaint also you need to set out the defendant incorrectly, without any basis, illegally has denied the execution of the agreement, and this is contrary to the record or whatsoever it is. So that the facts in contestation are critical, and they are therefore very, very important to be exhibited or exemplified clearly in the pleading, whichever side you might be on. Now, also, pleadings therefore are crucial in terms of being able to determine the issues which the court is required to try. Now, issues is something we will deal with specifically when we come to the later stages of the trial. But please bear in mind that issues can be contextualized in this way in either a soft form or a hard form. Now, under the CPC, issues are a expressly recognized stage of the proceedings, whereby the court looks at the contrasting documentation or the pleadings and then sets out the issues which are required to be proved by either party. So, for instance, in the example which I gave you, if it was a normal suit under the CPC, one of the issues would be, did the parties enter into a contract dated 21st of January, or was an agreement dated 21st of January so and so executed between the parties? Now, in the CPC, this is a specific stage, it's expressly recognized, but in all forms of litigation, whether it be a writ petition, whether it be arbitration, whether it be any sort of a dispute between a statutory forum, say the NCLT or the NCLT or the DRT, in a soft basis, there will always be these overarching issues which the ultimate adjudication will be addressed towards. So, in a writ petition, even if you don't have a formal proceeding where the judge concerned will list out the issues, ultimately, when the matter is adjudicated, those issues will come to the fore. For instance, there's an issue of maintainability. If there is an issue as to whether there is a violation of a constitutional right, if there is an issue as to whether the facts of the case justify a particular result. So, issues, whether they are expressly contemplated under the particular statutory mechanism or not, are elements which essentially undergird and underlie every form of adversarial civil litigation. Now, therefore, pleadings are very, very important in this context. But let's move a little more ahead beyond these overarching aspects. Pleadings are also very important in the sense that they also demonstrate if there is an ex facie cause of action. Now, see, ultimately, if you see particularly the Commercial Codes Act, also the CPC to an extent, there are shortcut provisions wherein you can avoid a full-fledged trial and seek rejection or decreeing of the suit at a preliminary stage. Now, to give you an example under the CPC, we will of course deal with this when we come to interlocutory applications. You as a defendant might ask for rejection of a plaint under Order 7, Rule 11. As a plaintiff, you may ask for a decree on admissions under Order 12, Rule 6 against the defendant without the need for a full-fledged trial. So a pleading is very important, not just in terms of the ultimate result, but also to ensure that you stay in the fight. If your suit is so shambolic or your defense is so shambolic that it doesn't even merit a trial, then you are essentially looking at let's say interim determination which completely obliterates the case for your client on the merits in the long term. So therefore, an ex facie cause of action or defense is disclosed in a pleading
For this reason also, it is very, very important. It also serves as a good guide for the proper mode of trial. So what are the issues in contestation? Therefore, what is the kind of oral evidence that is required? What is the kind of discovery of documents or interrogatories which is required? So these are elements, which are essentially to a large extent taken care of in terms of what exactly the pleadings say. Now, already we mentioned in the beginning with regard to res judicata in terms of the preliminary objections which one might take. So again, a pleading is what will determine this. So therefore, if your pleading makes it very clear that the very same issue was in contestation in an earlier proceeding, then that's it. It's the end of the story. Your suit's going to get rejected. Similarly, for order to rule 2, in the sense that was this part of the same transaction, and was this a relief you could have and should have taken in an earlier proceeding which was initiated between the parties or not. So these are very, very important aspects to be borne in mind when we talk about the importance of the pleadings. Now, obviously, whatever we are saying here is essentially then replicated across the board in the subsequent case laws, which have then been cited in this particular note. Now, again, coming back to essentials of good pleadings in the specific context of a pleading in court. I mean, essentials of good drafting in the specific context of a pleading in court. You are required to essentially establish that there is good matter, it is pleaded in good form, in apt time, and in due order. So, good matter in this context would mean all facts and circumstances necessary to constitute the cause of action. Good form in the context of pleadings, that they should be a logical statement of your case. It should be concise, it should be clear, it should not be ambiguous or vague in any manner. And more importantly, do not get argumentative. See, this is one, as I mentioned right in the beginning, try and be as precise as possible and avoid unnecessary statements. So, therefore, in a suit, don't get argumentative. Don't say, oh, the defendant is completely illegal what he is doing, he is completely obliterated the contract. These are things which sound very fancy, and these are things which you will essentially, obviously, maybe argue in the stage of oral submissions is there. But the best suits are those which are confined to the bare minimum in terms of what you are required to plead and prove. Now, this is something which I will tell you from example, that when I entered the profession and over the years, whenever you talk to senior advocates or judges who obviously have practiced at a time, when that docket explosion was not so bad, or the expectations from lawyers were a little different. Talk to me about how the best suits or the best plaints they have ever read are plaints which have been 7 pages in length, 8 pages in length. Now, to be very frank with you, even for someone of my generation, that is unthinkable to be able to stake a claim, say worth multiple crores, in a 7-page document. One feels that sense of insecurity. Oh Lord, what is this? It's a 200 crore claim. How can I plead it in 7 pages or 8 pages? So unfortunately today, possibly because of how the systems developed, all of us somehow equate length with how good a pleading is. So a lot of the times, a statement of claims before arbitrators, even plaints, in fact, before courts, you will find plaints running into 300 pages, 250 pages, 400 pages. So which is completely unheard of, at least for practitioners who used to deal with the CPC meticulously. So this is something which is unfortunately something which is developed in our system, in the sense that the conciseness of the pleadings is now overlooked in favor of an all-encompassing sort of pleading. And the underlying object of this, I'm not saying it's necessarily motivated by some malified reason, but many a times it's just to play it safe. That let's plead everything possible under the sun, so that tomorrow there is absolutely no issue when I am confronted with the fact that why didn't you plead this or that. So therefore it is very, very hard work. In fact, I think it's much harder to draft a 10-page pleading on a point than it is to draft a 100-page pleading on the very same point, because the kind of preciseness which you would require in a 10-page pleading is mind boggling as compared to a pleading that is far longer. Now, therefore, these are elements which one needs to bear in mind. And it must also be in apt time, because as I mentioned to you in the last class, one of the fundamental things you need to take care of is the aspect of limitation. So you definitely need to prove, or you need to plead that you've come to the court well within time. And of course, there is an issue of due order, that it should not be jumbled up. The facts must be clear, concise, preferably chronologically represented. That is the best way. I have seen certain plaints where there has been a back and forth in terms of the timeline, but it is better avoided, because mostly it does result in some confusion. That is what I would recommend. So therefore, that is essentially the importance of a pleading, the essentials of a good pleading, specifically in the context of what the court requires. Now, see, as I mentioned to you, there are multiple forms of litigation where the CPC does not apply anymore, in the sense of arbitration, statutory tribunals. Of course, writ proceedings have never really strictly applied. But it is important to understand that basically the groundwork for the system of pleadings in our country is laid through the CPC. So therefore, the individual provisions in the CPC, in fact, talk about, particularly in certain orders, it talks about what is required to be proved specifically in certain cases containing particular subject matters, or overall what is required to be averred and proved by a party in terms of what the plaint is supposed to reflect as a whole. So therefore, to give you one example, if you look at Order 7, Rule 1E, it requires the plaint to contain acts constituting a cause of action and when it arose. This is something specifically required under Order 7, Rule 1E. Now, for instance, if you look at Order 6, Rule 2, it requires that not only contain a statement in a concise form of the material facts, but it need not really represent or need not really reflect the evidence which you are going to lead in support of that proposition. So, to give you an example, again, going back to that example of A and B and the agreement, A is supposed to say, this person came, he sat with me, and he signed the agreement. But you don't necessarily have to plead in the agreement that Mr. So and so was the barista who actually served both of us. He will prove that the agreement was signed between us. Because that is a matter of evidence. That is something you will actually do in the oral evidence stage. In the plaint, you just have to plead the fact which is sought to be proved, and not the evidence which is going to prove it. Now, similarly, there are a lot of these overarching sort of principles which the CPC actually puts into operation. Now, most of these are, again, like I said, relatively commonsensical, in the sense that you need to prove the relevant averments, or to specify the relevant averments, which will essentially ensure that the specific relief which you are claiming before the court is actually ensured and is actually granted to your client. Now, again, I'm not going into each of this in detail for paucity of time, but this is a very, very good, concise note in terms of what the pleadings require you to do, specifically taking, let's say, inspiration from what the CPC says in this regard. Now, as I mentioned, this is something which can be said to be strictly applicable only to a civil suit, but you will do well to bear in mind these relevant averments, because ultimately, even if it is not going to be something strictly controlled by the CPC, the underlying spirit is something which will still be borne in mind. For example, under the Arbitration Act, you will find the statutory mandate is that the CPC and the Evidence Act do not apply to arbitration proceedings. It is explicit. But you have subsequent judicial pronouncements which have taken the view that even if there is no strict application, the spirit, now spirit again is a vague term, but the court says the spirit of the CPC and the Evidence Act can still be held to be applicable, say, to an arbitration proceeding. So, to give you a specific example, Order to Rule 2, technically speaking, only strictly applicable to arbitration proceedings. But there are court judgments which say that Order to Rule 2 can, in the appropriate circumstance, also be applied to an arbitration proceeding. So, again, like I said, which is why it's very, very important to bear in mind these requirements under the CPC in terms of what you are required to prove. So order 6 is the main rule, which talks about every single element of what you are required to prove in terms of the pleading, or to actually ever, I'm sorry, not prove, ever in terms of the pleading. And this is something which is very, very important to be borne in mind. Now, to quickly run through order 6 with you once, order 6 rule 2 we've already dealt with, and order 6 rule 4. Now see, one small exception to the rule that what is in written form will always prevail is that you will obviously possibly talk about elements like misrepresentation, fraud, undue influence. For instance, somebody may say, B may say as a possible defense, that A put a gun to my head and therefore he forced me to sign the agreement. Therefore, the agreement has absolutely no legal validity. So B is required to be very, very specific. He can't simply say, oh, B threatened me. He has to be very clear. I met B at Cafe Coffee Day. I met A at Cafe Coffee Day. A told me, let's step out for 2 minutes. When I stepped out, he shoved a gun to my head and told me, if you don't sign this, I will shoot you dead right here. Therefore, when he held a gun to my head, he gave me a pen and made me sign the agreement in front of him. And only once I had finished signing the agreement did he take the gun off and he told me, now you can leave. So you have required to be very, very clear if you aim to establish the elements mentioned herein, such as misrepresentation, fraud, undue influence, etc. Now, Order 6 Rule 6 says that if at all in a contract, or let's say in any agreement between the parties, even oral, there is a condition precedent, and that this condition precedent is fundamental to the performance of obligations, then this has to be specifically pleaded. And similarly, if there is this condition precedent, then you are also required to specifically plead that why this condition precedent was not met or could not be achieved by the counterparty. Now, this is something which is required to be specifically pleaded by either the plaintiff or the defendant, as the case may be. Now, another important thing is in terms of denials. Now, this is also very, very important. And in fact, unfortunately, we don't have the time for this, but it is most crucial, especially in the context of some of the more recent statutory formulations, such as the Commercial Courts Act, where your denials can't be vague anymore. Now, for instance, if A says in his plaint that A and B had an agreement, if B simply says, oh, there is no agreement, full stop, that will not be construed as an absolute denial and will be construed, in fact, as a somewhat limited denial, as Order 6 Rule 8 postulates. Therefore, if you intend to plead that the contract actually does not exist, it is not legal, it is not sufficient in law, then you are required to be very specific about what you actually intend to say in terms of what that contract represents for you. Now, it is also important that in the term of, let's say, paraphrasing what document says, see, be very, very clear. In pleadings, the general law is do not extract documents, text of the documents, do not obviously extract text from case law. In terms of documents, therefore, it is enough for you to say what is the purport of that document as briefly as possible, unless a precise word or a phrase in the document is critical. For instance, if you want to show that the defendant was under an overarching obligation to pay you money, if there is a term in the contract which says that once delivery is effected, irrespective of any dispute between the parties as to the quality of the material, B will make an advance payment, then that is a material clause, and a very specifically material clause, which you may extract. But the ground rule is, as much as possible, avoid extracts and just plead the material aspect which you want to essentially bring forth before the court or the adjudicatory forum. Now, if you want to essentially talk about the condition of mind of any person, again, it need not be something which requires a lot of elaboration at your end, because ultimately a state of mind is not something which can be pleaded in terms of much certainty. Now, Order 6 Rule 12 finally also says that if at all there is any contract which is sought to be implied, then it will be sufficient to allege such a contract and to refer generally to the corresponding conversations or letters without setting them out in great detail. So once again, like I said, it is somewhat coterminous to Order 6 Rule 9, that if you are referring to certain related documentation to actually establish an averment, it is not required for you to in detail deal with this proposition, as long as the fundamental averment in terms of its existence is set out in the pleading. Now, this note also talks about pleadings and evidence. This is something we won't go into today because we'll be dealing with this in the oral evidence section or module of the present course. Now, specifically to a defendant, though all of this, what we've spoken about so far, applies in equal force to a plaintiff as also a defendant. For a defendant, it is also specifically required that he must be able to break the case of the plaintiff without in any manner admitting to anything which the plaintiff has said in his plaint. Now, as I mentioned to you, that lurking danger of the plaintiff filing an application under Order till Rule 6 or an application for admission because of a vague or a vacuous statement which has been made by you in the written statement, or a statement of defense or a reply, depending on what is the litigation which is being fought. And be very, very clear that if you are merely traversing what is being said in the plaint, your traversal should be very, very specifically set out. For instance, you will see multiple written statements or defenses where the entirety of the paragraph in the plaint is reproduced, and simply at the end there is one word saying denied. Now, this is not sufficient. If you are traversing what the plaint says, your traversal should be specific in terms of what you are admitting and what you are denying. Therefore, if you are denying every single aspect of that plaint, be very, very specific that every single aspect is being gone through. Also, one very important thing to bear in mind: as a defendant, mere denials, bare denials, can lead you into significant trouble. It is not sufficient, therefore, in a lot of cases. For instance, if there is an averment to the effect that, let's say, in a property dispute between family members, if there is a averment to the effect that A received certain money, certain properties from his father, your response cannot be the averment set out in the plaint are a matter of record. Anything which is not a matter of record is denied. This is one phrase you will find regularly appearing in a lot of defense statements because it doesn't involve much application of mind. It's easy. Nowadays, the way pleadings are being construed, it is no longer sufficient. It is bad form to just respond to everything in the plaint by saying everything which is a matter of record is admitted, what is not a matter of record is denied. That might help you in the context of equally vague pleadings in a plaint. But if a plaint is specific to say A and B met, A and B signed this agreement, you can't get away by saying, oh, it is as per the record. If it is not a part of the record, it is denied. This is a good strategy for certain cases where you are stuck in a rut. You don't know exactly how to engage with or respond to what the plaintiff is saying, because any form of engagement you believe might result in an admission. So, in that circumstance, possibly this is a strategic imperative. You may go ahead. But unfortunately, this very, let's say, rare utilization has now transcended and evolved into almost the entirety of a written statement or a defense. You will find a cut copy paste of this phrase everywhere, and which can lead to devastating results in terms of what you are required to do. Now, to just end with this, possibly to give you a good example of how destructive the inability to plead properly can be, please go through the Commercial Courts Act. The Commercial Courts Act sets out extremely stringent requirements in terms of what you are required to prove or plead by way of amendments to the CPC. Now, I did do a talk on the Commercial Courts Act. You can search for it on YouTube. Put my name and Commercial Courts Act. you will find a talk. It's a really long talk because there was a lot of Q&A also. But for those of you who are interested in terms of the specialized regime under the Commercial Courts Act, you can just take a look at that particular talk, and where we went through these different amendments to the CPC in relation to commercial courts, and as to how they impose extremely stringent requirements and timelines on parties that are essentially litigating a case before a commercial court. So this is essentially, what I wanted to communicate in terms of pleadings. Again, like I said, it is a little difficult to be able to explain this in a sense which is like purely academic or theoretical. So ultimately, it is probably best learned or best expressed once you go through the record of a particular case, or once you go through the pleading in a particular case and possibly see how that pleading has then been considered throughout the stage of a civil proceeding, in the oral evidence, in the trial, in the oral submissions, and finally how these pleadings were then interpreted by a court in the ultimate judgment. So maybe you can possibly look at certain judgments, where these pleadings have been considered threadbare, and maybe by that maybe get a slightly better idea in terms of what exactly this process contemplates. So therefore, it is very important, I mean, again, to repeat myself, that you pay very, very clear and very, very detailed attention to the pleading stage, because this is really the stage or the platform which launches your litigation as such into the courtroom. So that's it from me in terms of this particular aspect. And if there are any queries, you can just reach out to me. I think there is already one query. Just yeah. So there are a couple of questions. Yeah, taking Anurag's question first. What is the consequence of introducing new arguments? So and so. Yeah. So see, that's a very, very good question, Anurag. Something which happens very regularly in courts. See, if you take an argument which owes its existence to a factual proposition, it is possibly not good strategy to try and make that submission for the first time at the oral argument stage. Now, one caveat here. This response is in the context of a full-fledged civil trial, which involves elements of, as I mentioned, admission denial, which we will come to, framing of issues, oral evidence, etc. Because in the case of a full-fledged trial, whatever you are trying to demonstrate factually is supposed to pass through this filter of this process. So, in a civil suit, in a full-fledged civil trial, it will be difficult for you to take up a new argument at the final stage, and you run the very real risk of the court or the tribunal refusing to accept that submission on the short ground that this is a factual argument which has never seen the light of day before, and the other side therefore has never had a chance to rebut the same. Now, this is as far as a factual argument is concerned, but strategically speaking, yes, there are things which you want to keep hidden, which you want to spring on the other side at the final stage. Now, this can be done in two ways. One, in a case where, for instance, in a writ petition, or say in a matter before the NCLT, where there is no question of, say, oral evidence, you are only required to argue on the basis of the record before the court, which may be admitted or denied, whichever way. Then you have more of a leeway, in the sense that you will also be able to argue matters which the documents may evidence, but which may not be expressly averred by you in your writ petition. So, in such a case, you have more leeway to be able to argue a point at the final stage, despite there being no specific averment to that effect in your pleading. Again, in the case of a legal argument or an argument that is not completely borne out from the facts, again, like I said, you have significant leeway. Even in the case of a CPC trial or in the case of an arbitration trial, if what you are arguing is something which has been reasonably talked about, or reasonable contestation thereof has happened in the pleadings, and what you are arguing is only an offshoot of what is otherwise in controversy between the parties, that is again an argument which you can get away with. So as a thumb rule, try and avoid masking an argument or masking an averment which is purely factual. But as long as you can demonstrate that that factual averment is actually an offshoot of a factual dispute between the parties, which has already been enmeshed and already been taken care of in the trial, or if your argument you are able to postulate as a pure argument of law, then possibly these are arguments which we can keep to the final stage. Ultimately, you need to, again, like I said, do a risk benefit analysis and just take a call in terms of how effective it will be as a strategy when you weigh the surprise element as opposed to the possibility of the tribunal saying, sorry, nothing doing, you missed your bus, this is something you should have done at the initial stage. So I think it's the subject of the argument, the nature of the argument, which will ultimately determine the answer to this question. Right. Now from Umang, yeah. A and B, let's say discuss for 3 hours because of this. There's a chance B will bring it up. Right. See, now ultimately, as I mentioned to you, this is a point which effectively helps B. Now, when you decide what you need to plead or what you need not need to plead, you need to only be aware of the fact that there should be no suppression on your part. Now, legitimately speaking, from the law surrounding execution of contracts, you will find a lot of case law which says that once a contract is signed, what happened prior thereto in terms of discussions is irrelevant. There are some exceptions, but that's the general law. You will also find case law which says that once an agreement is signed, subsequently thereafter, even if parties discuss the possibility of modifying the agreement, editing it, novating it, this novation or modification must be expressly represented in writing. And this is because most contracts will contain a clause like the same, that any modification, etc., can only be in writing. So if you look at it from that context, what you spoke about an hour back, what you spoke about an hour later is completely irrelevant to the controversy. And you are not saying this on an ipsy dixie. This is what the law says. So therefore, when B brings it up, this is something which B requires to prove, to show that this had any impact. So if it is something which legally is inconsequential, just because B brings this up and you say in A, yes, of course we spoke for an hour early, of course we spoke for an hour later, but it has absolutely no impact on this controversy. So Umang, to answer your question, if it is something relevant and you don't plead it, then you are absolutely right. The court may construe it as a suppression, which is problematic for you. But if it is something irrelevant, for instance, B says, oh, A was wearing a yellow color shirt. I hate yellow color shirts, so therefore I walked out of the meeting. That is again completely irrelevant. The color of your shirt, at least from the perspective of you pleading what you have to say. So therefore, as I mentioned, as long as it is something which is not relevant to the controversy, as long as it is an argumentative element, it is perfectly all right for you to decide not to plead it. As long as tomorrow there is no chance of you being accused of suppression. So that's like a ballpark or a benchmark, which you can bear in mind in terms of determining what is it that you need to plead and what is it that you can actually get away from pleading. Right. Any other questions? Because this, as I mentioned, this is a very fine balance, and it's a balance which we essentially have to ensure that we meet on a daily basis. Every case is different. Every case's factual complexities are different. The legal position is obviously constantly shifting. So again, like I said, this is a very organic, dynamic process which is required to be taken as and where it comes. But which is why, again, I think it's important that when you do internships in the future, whenever you guys do any sort of a litigation internship or even a corporate law internship, please look at drafts from these perspectives instead of just reading through a draft generally in the form of, say, casual reading. Whenever you do your internships in the future, please look at pleadings or please look at transactional documents from this perspective, so that what we are talking about here will be better exemplified for you in practice. So if there are no other questions, we can possibly call it a day for today. And tomorrow we will essentially look at maybe not such a critical subject, but maybe something more practical in terms of the entire process of filing. How do you approach a process of filing? How do you put together a paper book? And of course, the most torturous aspect, which is dealing with the registry of the court or the forum which you intend to approach. So that's what we will deal with on Monday. Right. All right. Thanks a lot.